to defend them correctly. And then in a lot of cases, they're simply uninterested in their clients. Some of these problems are inherent in the public defender's office, specifically heavy caseload. In my research, upwards of 30 cases a year in many cases. And then in major cities, I was looking at New York, they take on 592 cases a year, whereas it's recommended that you do 150. Obviously, if you have 592 cases a year, you're not going to be able to do the adequate research and preparation to defend those clients properly. In addition, the salary is not nearly as high as it should be. In many states, the average salary for a public defender is less than half of the national average for people with the same level of education. And so this sort of plays into the previous one. Not only are they not getting paid enough for a case, they'll take on more cases to compensate for that. Also, many public defenders have a lack of experience and a high burnout rate because of these problems as well. So even though having more experience would better prepare you to defend a client, oftentimes public defenders won't make it that long to get that experience because it's not a very sustainable career. There's also the problem of attorney perspectives and goals. In many cases, attorneys have a disbelief in their client's potential innocence, so they won't do the same level of research and preparation as they would if they didn't believe that. Sometimes there are biases against their clients, whether that be in Chicago specifically. There are a lot of racial prejudices as well as class issues. Attorneys are less likely to devote the same amount of attention in these cases. And then something that's a little bit less obvious is the emphasis on winning over proving innocence. I read a book called Defending the Damned, and it was about the public defender's office in Chicago, and the picture that they painted was of very effective lawyers who were very dedicated to their jobs, not at all like what I've previously been describing, but they viewed it as a game. And even though that can work in some cases, especially in the case of wrongful convictions, when you're trying to look at court technicalities or errors on the part of the prosecution, you're not always looking at ways in which you can prove your client's innocence. And a lot of this has to do with the adversarial system, which my fellow presenters have talked about. It lacks a focus on truth finding, as well as causes an imbalance of power. The prosecution has a lot more resources available than defense lawyers. In the United Kingdom, they've sort of started taking on a more inquisitorial system with a focus on information. Judges are now more informed and granted more power. They play a more active role in the process, and they're now required to have more information on the case, whereas in the United States, it's not always practiced. As well as there are reforms that have done away with some of the previous inherent advantages for the prosecution. So just a little bit of UK comparison. The Public Defender's Office is generally better resourced, more organized, and better funded, as well as the government will fund private defense that's outside of the Public Defender's Office, which we don't do here in the United States. The system of appeals is also different. In the United States, it's part of the court system, whereas in the UK, they have the Criminal Cases Review Commission, which is independent. The appeals courts in the United States can only consider procedural, not factual errors, so no new evidence can be presented, whereas in the UK, they're encouraged to hear new evidence and they can gain a better perspective on the case after it's been heard. There's also a more narrow standard for overturning a case in the United States than in the UK. So some of the remedies for this would be better funding for public defenders. This will result in lessened caseloads, and as a result, there will be an improved quality for each case. There also can be more incentives to become a public defender. If it's a more competitive field, then the lawyers will be better qualified. Wrongful convictions can cost millions of dollars, so this funding would end up being saved by having higher quality defense. We can also enforce stricter defense quality standards, including, as mentioned, the caps on caseloads, so that lawyers are devoting more attention to cases rather than having so many of them, as well as a higher scrutiny on appeal. In many of these cases, the problems that we've all brought up today, they could have been not prevented, but at least we could have brought more awareness on them, but a lot of times the attorney didn't bring them up, and sometimes this is ignored on appeal. We don't really like to look and say that the defense didn't do a good job, so a higher scrutiny could prevent some of this from happening. As well as an increased focus on information. Like in the UK, a more inquisitorial proceeding will result in fewer wrongful convictions, and then reforms to make sure the defense and the judge have access to all the facts of the case, rather than most of it being solely within the possession of the prosecution.
I think you all did a really great job. You didn't join him up there. I'm going to point out a couple things. What I think sometimes gets lost in pointing out all of the issues with prosecutorial misconduct and with police misconduct as well is that a lot of these mistakes are not being made maliciously. They're being made by well-intentioned police, well-intentioned state's attorneys who are overworked, overtired, underpaid. A lot of the problems that you guys identified. So I thought it was really good. A couple of you, Clay and Abby, I think, noted that increased pay and decreased workloads would go a long way towards rectifying some of these problems. And as I mentioned before, and as Phil well knows, that is not the offering. I also just wanted to point out a couple of you said that judges are always elected in the US, which is not actually true. So it kind of depends on the district, whether it's a district court or a circuit court, it goes state by state, and there are different rules for that, but there are appointments in the US as well.
I would also add that I think that you pointed out so many issues between the three of you, very thorough examination here of some of these issues that prosecutors and defense attorneys face. And I think that one issue that kind of relates to a little bit, Abigail, you mentioned about in both of your wrongful conviction cases that you highlighted about the issues with probability. And I think that's part of the problem is that when we're dealing with wrongful convictions, many of the topics or factors that lead to wrongful convictions involve scientific evidence. And with the exception of perhaps Katie and Phil here, who have some knowledge of these different topics, a number of attorneys, they don't have any training in science. And so you're dealing then with topics that they may not, as Katie said, maliciously misuse, but may simply, out of ignorance, not fully understand. And so I know my colleague and I are starting to look at what do prosecutors, defense attorneys, and judges understand about scientific evidence and wrongful convictions. So maybe one day I can report back to you with those data. So great job.
I echo the general call for more funding for public defenders. I'll say that, Wendy, I think you're absolutely right, that the highest amount of accountability that you can attach to the job of prosecuting crimes would go so far in countering instances of prosecutorial misconduct and wrongful convictions in general. I think when we romanticize the job of a prosecutor, it's to seek justice over everything else, but in the nitty-gritty, day-to-day execution of that job, it comes down to winning. And the real pressure that they feel is to win, just like the real pressure that the police feel is to get an arrest. And they don't so often look past that local goal to actually seek justice. And I think that the issues that Clay brought up about shortcomings in defense. I think both of those issues where prosecutors might be doing something improper, knowingly or not, and the defense might be struggling to keep up. I mean, they're so often present in one case, and a frustration I deal with regularly is on appeal, you're supposed to present these issues as discrete, separate issues. But in a courtroom drama, they're contributing factors to the same miscarriage of justice very often. And I think it's a reluctance on the court's part to recognize that these issues can have a synergistic relationship that alone might not prevent a wrongful conviction, but together tip the scales against the innocent. I think that's where a lot more, I mean, and there are so many multiplicitous, factors that contribute to a wrongful conviction. You guys, with this two-sided presentation, have really, I think, brought forth an excellent example of that, so thank you.
Finally, Dexter. I know you were disappointed about being the last one, but you're like the headliner, so think of it that way. Like you've had 9 or 8 rather openings.
Yeah, I get to bring you guys all home. So. Short guy. Okay. My name is Dexter, and my topic is police misconduct in the LGBTQ community. I chose this topic